we're going to talk to you about negotiating a DPA. And what we're going to do is we're going to do a scenario. We're going to have a bit of a mock negotiation. In order to do that, I think we're going to have to take you back a year or two when those of you involved in GDPR were probably handling thousands, if not tens of thousands of DPAs crossing your desks. And for a lot of companies, it was just a papering exercise. Some of them got signed, some of them got ignored, some of them got negotiated, usually as fast as possible. What we thought we would do would just go through one and just look at some of the issues and the sort of arguments we hear on both sides. So I realize as we're doing this, some of you may start twitching, recalling a grim time in your lives. It may be like a Vietnam flashback or something like that. But anyway, and if you want to interrupt or shout out or get involved in the negotiation, that's fine too. We'll just try and make it as interactive as possible. So Jamie is going to introduce the scenario.
Okay, so it's probably a reasonably familiar scenario to those of you that have worked on data protection agreements. You've got an EU customer, and it's looking to update its HR and accounting system. So it's going to be procuring services from a service provider who we're calling very originally Cloudy HR. And we're talking about a package of services. So you've got some cloud software, some hosting, but also some support and maintenance and related professional services. So there's a suite of services being procured. For the purpose of this, we're going to say around £1 million a year, there or thereabouts. And we've just received, we being the customer, has just received the service provider's standard data processing agreement, been asked to sign it. So for the purposes of the exercise, my colleague Mr. Watts here is going to be playing Cloudy HR's in-house legal advisor.
And the lawyer representing the customer will be played by my colleague, Mr. Jamie Drucker, over here. Right, so it's 9 o'clock in the evening. We have sent over, it's a Friday, we have sent over a perfectly reasonable set of clauses that are super fair and have been signed by thousands and thousands of customers without any complaint whatsoever. Now, you know what it's like sometimes when you have a relatively junior, inexperienced lawyer on the other side. They might see problems where there aren't any. But anyway, we want to get the deal done. It's coming up to end of quarter, so we're not going to just tell them to go away. We are going to take some of their points, but I'm going to limit them to 4 points. What is your first point?
Well, I'm going to talk very slowly and loudly for your older ears to handle it. So I think we'll start with information security. Let's do information security, Mark. Start with that one. So this is what the clause looks like. Cloudy HR has implemented the technical and organizational security measures specified in Schedule 1. We will spare you Schedule 1, but you can start to imagine what that might look like. Customer confirms that the security measures are appropriate to the data processing. So that's the clause. How might I react? So I suppose the first thing I might say is, this doesn't work, I'm going to insist that the service provider says that the security measures are appropriate rather than the customer saying that. Might be one reaction. I might just say, I'm a lawyer, this sounds like an information security issue. Let's get my InfoSec guy to look at it. Assuming it's all fine and looks reasonably sensible, let's move on. Or it's pretty late on a Friday and I think it's fine. I'm not going to admit this in front of Mark, but Love Island is my show. So on balance, I think let's go with A. So what do you think, Mark?
Well, so what will I say here? Well, I guess I could explain the challenges faced by a supplier regarding IT security and explore some sort of compromises. I may well ask, who does this young whippersnapper think he is? We're a big supplier, it's our way or the highway. Or I may fess up that actually I'm also quite a fan of Love Island. So let's agree this as fast as possible. Of course, if I capitulate right now, this is going to be the shortest session ever. So what shall I do? Okay, let's explain the challenges. So what might I say to Jamie? Well, IT security is just like any other IT service. You have to pay for it. Just like coding. You don't get coding for free. And IT security it's not just, well, you lock the doors, close the windows, and that's security. It is an active thing. So people need to be trained. Servers need to be patched. Access controls need to be managed. You have real people, or geeks at least, you have real people doing real things and being paid real money, and so there is a cost associated with it. So you can't expect to get some all-you-can-eat security buffet, which seems to be what you're asking for. What else might I say? Well, we have to provide appropriate security, but we don't control many of the factors, or I would say any of the factors, that go to determine what the risk is. So GDPR helps us out on this. Article 32 gives some clues as to what you should think about. You should think about, well, what's the state of the art? What's the type of data? What's the context? What's the risk? And all of those things go into the mix in order to figure out what appropriate security should look like. Now, what do I control there? Do I control the type of data? No. The risk? No. The state of the art? No. So all of the things on which appropriate security is sort of keyed off are out of my control, which makes life very difficult for me, clearly. And finally, we'll do whatever security you want. We're an IT company. We have awesome security. We have every security certification you could shake a stick at, but you need to tell us, we need to contract for it, and you need to pay for it.
Nonsense. So what I would say in response, let's start with the law. So Article 32, which you already mentioned, which says you have to have an appropriate level of security, applies to you just as much as it applies to me. So you already have to say that the security measures are appropriate. You can't lean on me to tell you that. You're talking about the state of the art. You know, as an IT security provider, as an IT service provider in this space, you're well placed to say what the state of the art is and to benchmark against the market in terms of what's an appropriate level of security. You also said we have to pay for security, but we feel like we are paying for it. We're paying £1 million a year for this contract. We would expect a certain minimal appropriate level of security to be baked into that contract price. You also said that you don't know what data is going to the system, so how can you determine what's appropriate? And what I would say in response there is, you should know exactly what data is going to this system. You have built an HR and accounting system. It should come as no surprise to you to understand what data we're likely to be putting in it. It's the standard HR and accounting type of thing. And so we rely on you as the expert to come up with an appropriate level of security given the type of data that is normally processed for these type of transactions. And that's one of the reasons we chose you, for your professional expertise, and that counts for making the service work, but it also counts for making the service secure. We also don't know your IT security environment, so we don't know what the most appropriate configurations are for the type of measures that should be put in place. The service provider knows this. The service provider can determine what's appropriate given its internal knowledge of its systems. And then just to come back to the law as a final point, obviously we've got Article 28, which says that the contract has to say that the processor will put in place appropriate security measures. So, we can dance around this a bit, but that's what the GDPR says. So where does that leave us?
Well, what I would say is we have a statutory obligation to have appropriate security. I hear you. We just have to do that. As I explained, the factors that contribute to what's appropriate are largely outside of our control. We may have some inkling what the state of the art is, but we certainly don't control it. I don't think it's unreasonable to expect our customer to take a look at our description of the security measures that we may have proposed and to say, yeah, I think they're good enough, because you have an obligation in relation to appropriate security as well. As regards this idea of it's an HR system and we know the data, we do know the data, but we know what the system does generally. We don't know what you're saying to your individuals. We don't know how litigious they are. We don't know what happens to the data, who's using it once it's out of the system. There are other factors that could contribute to a problem that are really outside of our control, I would say. And on the final point about the contract, what Article 28 says is you've got to have a contract that respects Article 32. It doesn't say you have to use the magic word appropriate security.
Okay. But I mean, if you've got a contract that refers to Article 32, just by incorporation, you're bringing in a level of appropriateness to the security measures. So I just don't know that we can get round that. We have to find a way of drawing in Article 32 into our agreement.
Well, I don't know about you, but I've really had enough of this guy. So it's getting on a bit. The weekend started a few hours ago. Let's try and compromise. So after a bit more back and forth, I can get the clicker to work. There we go. That's what we started with. So where did we end up?
So Cloudy HR will implement the technical and organisational measures required by the GDPR, is where we settled, and those specified in Schedule 1 when processing the data in the service provider's environment. And then separately, the customer will inform Cloudy HR of any circumstances that would require additional security measures. So from my perspective, this is better because we've got a reference to GDPR. So from an Article 28 compliance perspective, that this feels a little bit better. You're bringing in a level of appropriate security measures certified by the service provider here. And also, I would say, because of that, the obligation to notify them of additional circumstances requiring additional security measures should feel like more of an exceptional case.
And from Cloudy HR point of view, clearly I was in a very generous mood when I agreed to this. It's not all bad. The reference to Schedule 1 is helpful, even though it's non-exhaustive. The fact that there are measures that are specified in Schedule 1 gives me the opportunity, if I'm being asked to do something unusual that I wouldn't ordinarily do, it gives me a chance to, one, figure out if I can do it, and two, think about if there's any price implications. The reference to in our environment, we do see, particularly cloud providers and other providers actually, trying to limit the security obligation to just their environment. The idea is it's just the bit they control, their part of the world. And then the obligation on them to tell me of anything unusual, any changes perhaps going forward. Maybe they start loading data. Maybe they didn't have much sensitive HR data historically, but there's a business process change that means they start processing that, and that goes into the HR system. I mean, you'd hope the security would be good enough anyway, but just in case, it would be good to know about that, just in case I need to do anything else. If I could get a little bit more, I'd probably want it not to just say, Cloudy HR shall. I'd want some sort of acknowledgement from them, maybe, that the security overall is appropriate. But anyway, that's not a bad place to land. I'm okay. That's 1 out of 4. What is your next point?
Let's do sub-processing. So this is the clause that I've received. Customer agrees that Cloudy HR may, at its absolute discretion, engage Cloudy HR affiliates and third parties to process customer personal data in providing the services. So, what might my reaction be? It strikes me that as my career progresses, the quality of my Friday nights has got worse. So I could just go with this, let's just get on with it. I could go the other way and say, absolutely not, you're not using sub-processors. We wanted you, we didn't want any sub-processors, let's strike the clause. Or we could do something a little bit more nuanced. So we find a way of imposing a consent requirement for sub-processors, but maybe there's a bit of a discussion to be had about how that consent requirement works as between Cloudy HR affiliate group companies and third parties.
That's what you're going to do.
Let's go with C, I think, on this occasion.
Right, well, God, I'm over this too. I'll agree to anything as well. I've told you we're a big supplier. It's our way or the highway. But no, we're in the mood to do a deal with Jamie. We're going to explain how subcontractors are used for our service and what our responsibilities are. So what is that? Well, we use sub-processors to support the service. So the prices are low. We are heavily dependent on a lot of third-party infrastructure. They're all technically be sub-processors, so we have infrastructure providers, software providers, hardware providers, telecoms providers, support providers. There's a follow-the-sun model involving other parts of Cloud EHR around the world, so they're involved as well. You want follow the sun, so other people have got to be involved. You can't expect us to stay up all night. So we do need to involve others. In addition, when it comes to changing subcontractors, we can't be beholden on you for your consent because the service underpinned by these sub-processors is identical for all customers. And we can't, if we want to change a sub-processor, we can't have a sub-processor in for some customers and not in for others. It's either in or out as far as that goes. In addition, we remain responsible for our sub-processors. So think about our affiliates. We run a global privacy program. They're all bound by the same requirements. Whether it's us or one of our affiliates, they're all doing the same thing. We remain responsible for them anyway, so you shouldn't worry about that too much. And if you're really bothered about it, if, as we go along, you see something you don't like, you have the right to terminate if you don't like a proposed sub-processor.
Okay, so the first thing to say here is that as a controller, we have a statutory obligation under the GDPR to only use processes that can give us guarantees that they can meet the requirements of the GDPR, and that flows through processors to sub-processors as well. So as a result of that means we have to do something not just contractual, but we have to do some due diligence. Now, we have done a lot of due diligence on Cloud EHR. We've looked at their information security practices. We've spoken to their privacy team. We've spent a bit of time doing some review of their policies, and we're broadly happy with them. But we're now being asked to accept the fact that they might pass our data to a number of unknown third parties who we haven't done the due diligence on. So that's a problem for us. The second thing to say is you mentioned termination, but we're talking about critical internal systems here. We're talking about HR, so our employees who we owe a duty of care to protect their data, but also our accounting systems. So if the accounting system goes down or we're without an accounting system, we're not going to get paid. So it really isn't good enough to say you can just terminate on short notice because we're getting rid of our legacy systems when we go with Cloud EHR. So that doesn't work from our perspective. And then finally, to come back to the GDPR again, you've got Article 28(2), which says they need our consent to sub-process, and the contract has to say that. So we need to find a way of building in a consent mechanism whilst also recognizing, and I do recognize, that you may be in a difficult position requiring a specific consent in every case.
Okay, well, you talk about diligence. We do diligence as well. So it's not in our interest just to hand your data or anybody else's data to anybody. So when we look at proposed subcontractors, we would do a lot of diligence on them. So you ought to have a level of trust in us from that point of view. And in terms of consent, that's what the clause says. We want you. I'm telling you, we use subcontractors. If you don't like it, go somewhere else. We need your consent. That's what the clause is getting at.
But at the moment, we don't know who they are. It's just a general.
I'll tell you who they are.
Okay. How are you going to tell me who they are?
I will put together a list of who the subcontractors are. Yeah. And you can have a look at it.
So I think we're going to need to know who they are if we're going to be relying on some of your due diligence that you've done. Mm-hmm. And the GDPR, as you know, also says that where you're getting a general consent, we have to have a right to object. So how's that going to work?
Well, let's forward wind and see where we landed. So that's what the clause originally said. Not too much of it survived on this occasion. So we're now, and this is probably a sort of formulation that you're reasonably familiar with. We agree they can use the sub-processors. They will list the sub-processors on their website. You might put it in a schedule if it's a shorter list. Having it on a website is quite handy. And then before they appoint a new sub-processor, we get given a right to object. We get 30 days, and we can object on reasonable privacy-related grounds. And then if, notwithstanding our objections, they go ahead anyway,
then the right to termination comes in. So from our perspective, this is better. We have a bit more control. We can see who the initial list of sub-processors are, so we can start to check that we're comfortable about the initial list, make sure there's no companies on there that we're not comfortable with our data, having access to our data, and then the objection will just apply in case of changes. And the window that we've got here, it's not great, but 30 days potentially gives us a little bit of time to get our house in order if we think that ultimately we're heading for a dispute over a sub-processor and we may have to look at a termination or a suspension.
And so from our point of view, I mean, it's kind of hard to push back on the idea that a customer says, can you tell us who's got our data? It's sort of hard to say, no, it's a secret. So the idea of a list is okay. I mean, we see a list used quite often. You can put all your affiliates on it. There's quite often a conversation, though, as to, well, who should go on the list? Where does the chain of subcontracting actually end? Hardware providers, what about them? What about the security company that walks around the data center at night? Do we put them on the list? So there's a bit of thinking to do there. The 30 days, that's okay. On the 30 days, I don't want to have to tell Jamie's customer individually that we're changing subcontractors. So I would need a mechanism just to do this across the board for all my customers so that it's programmatic. Otherwise, this would be quite difficult to live with. They can only object on privacy-related grounds. That's sort of helpful. They can't terminate. They can't wriggle out for it and use this as an excuse in some ways. And it talks about termination. What it doesn't get into is whether there's a termination charge there or not. In this situation, I would suggest not, but you do. But then I've just changed sides, so why would I do that? But one does see that from time to time. Right, 2 down. What's your third point, Jamie?
Let's go with data transfers. So this is what I've been presented with.
What's wrong with that?
Cloudy HR may transfer customer personal data anywhere in the world as necessary to perform the services.
Do you want the services?
So the arguments we might make here. So the first thing to say is both parties...
Sorry, my clicker's not clicking. There we go.
There we go. Both parties have an obligation under the GDPR to transfer data in accordance with the international data transfer provisions. So you have to come up with an appropriate mechanism for the transfer. So either we agree now that this is an EU-only service and the data is localized in the EU, or we have to do something more than that contract term to put in place an appropriate measure for the transfer, because currently the clause is just non-compliant. That's the first thing. The second thing is, I've talked already about this being critical data for us. These are our employees. We have a duty of care, and we take our transparency obligations in relation to our employees very seriously. And if we don't even know where the data is, we don't know where it's located, what can we reasonably tell our employees about how their data is being processed in employee privacy notices and in our general employee comms? And sort of aligned with that, if we don't know where the data is, we potentially don't know what other laws may apply to it. So there may be additional regulations that apply to the data when it's held in certain locations. There may be government and regulatory authorities that have powers in relation to that data. And so if we don't know where it is, we can't risk assess that. And then there's another point here, which is if you are solely determining where the data goes and we have no say in this, are you not starting to move towards taking some decisions about the critical means of processing here that may just tip you over into taking on a controller role? And let me tell you, if you do become a controller, that's a problem for both of us, because we haven't worked out whether we've got a lawful basis to share data with another controller in this scenario, and I'm pretty certain you will not be able to meet all of the controller requirements around transparency and lawful basis yourself.
Okay, well, how might Cloudy HR respond? I've explained very briefly how their services are configured in terms of subcontractors. Well, those subcontractors are all over the world. There is data literally going everywhere. I don't mean to alarm you, but there is. So we need flexibility to transfer the data to where it's needed for the service to be provided. We also are changing our delivery model from time to time. So we do move data around. So it's complicated now. It may also be quite fluid. In the future, it may change. We need the flexibility. And we don't want to have to come back to you each and every time for consent to this, consent to that, just because we may have one new subcontractor working from a new territory or something like that who has visibility of the data. And in any event, as you've already nailed me down on security, we keep the data secure wherever it is. So it doesn't really matter so much, does it?
So what I would say on security is, I think just when you read the GDPR, you can see that transfers matter because it's a separate obligation from a security obligation. There's a reason why the GDPR deals with international transfers as a special set of rules. And so we do need something in our contract that makes both of us compliant in terms of transferring data abroad. So I think we recognise that you may want to provide the service from a number of locations, and that you may need a bit of flexibility in your service model. But that's all up to a certain point. And in order to be transparent and in order to meet our obligations to our employees, we need to know a bit more about where the data is and the circumstances in which it might be in each location. And also we need an appropriate measure in place to get around the prohibition on transfers.
Well, let's see where we get to on this. That's what the clause used to say. Okay.
So now we've got Cloud EHR can transfer the data to countries outside the EEA, provided the transfer is made subject to a valid transfer mechanism, and then there's a couple of examples, Privacy Shield and standard contractual clauses, or where separately we've otherwise agreed in writing. They may do so. So this feels like a more GDPR compliant clause. It builds in a mechanism by which we can put an appropriate transfer measure in place, and it allows me to make certain statements to my staff about how and where their data is held. We may need some additional drafting around how these mechanisms are put in place in practice, but this is the kind of starting point.
Yes, and this isn't too bad for us. I mean, this is typical. I would say it's kind of hard to act as at least a successful service provider without having some answer in relation to data transfers. It's pretty open, and I get to choose whether Cloud EHR will enroll in Privacy Shield, or whether we'd rely on model clauses, or both, or do something else. The or where customer otherwise agrees in writing is sort of helpful for both parties, really, to deal with an ad hoc situation where maybe there is a new transfer, maybe it's ad hoc, maybe it's just, that one support issue that the usual guy couldn't fix and the data needs to be transferred somewhere else. It's going somewhere new that's not covered by model clauses. Maybe it's ad hoc, maybe it's low risk, maybe we'd be happy to do it as long as they agree that we can in writing, that kind of thing. So, and this, again, is fairly typical, I would say, in terms of where things land. Right. Last point, the big one.
A minor point to finish.
Yes.
Let's do liability.
Okay.
So this is what I've been presented with. Cloud EHR's total liability to customer for any breach of the DPA shall not exceed the total amount paid by customer to Cloud EHR in the previous year. And we saw from the original screen that this is a £1 million a year contract.
I literally don't see what the problem is.
Feels to me, firstly, that you're not very well incentivized under this to treat my personal data or my company's personal data seriously. If there was a breach, and as you know, data protection is a very serious matter, there isn't really an effective remedy for me to require you to protect the data if the maximum I can recover from you is £1 million. So I really think you need to back your product here, back your security measures that you spent some time telling me about before, and up your liability a little bit here. The second point, this is around assessing what our risks are. So we could be hit with a big fine, as you know. We've also seen recently the beginnings of what start to feel like class actions. People will be familiar with the Morrison's case. And obviously, if you have a big data breach, cumulative claims, many thousands of people, that head of loss could be very significant. That's just part of it. Of course, even if there's a breach and ultimately there's no fine issued, I'm going to have all sorts of costs on remediation, investigating the breach, professional costs, forensic IT. That really does start to add up in the event of a problem. The other thing to say is the way the clause is formulated, if there's a breach 6 months in, I've got no recourse at all because I've not paid any money yet. So we'd have absolutely zero remedies in year one, and the risk is just as high in year one as it might be in year three. So that doesn't really help me at all.
All right. So
And finally, it's a one-way liability clause. So I've got unlimited liability to you.
Yes.
That doesn't seem very equitable.
Well spotted, young man. Right, what might I say to that? Well, IT security, as I keep saying, is just like any other service. There are many, many ways that we, Cloudy HR, could screw up your business. We could not deliver the service at all. You may not be able to pay your people. You could incur all sorts of liability, and for those types of liability, you have already accepted, you may not know this, but you have already accepted the overall liability cap. So a security-related liability is kind of no different. It's just another type of liability. It's just another way your business could be harmed, but it's not special, so the cap is the cap. Also, you mentioned fines. You've been banging on about how we have an obligation for security, for appropriate security under GDPR. Absolutely right, we do. That means we could get fined. So if we get things wrong and we lose your data, it's at least as likely that we're getting a fine, not just you guys. So it's not a case of you having to pass that on to us, I would say. Next thing. You may not have noticed this, but we are an IT company. We are not an insurance company. You do not get unlimited insurance over any liability bundled in for free. You could go off and buy some from somebody else, but you don't get it just as part of the services. And finally, this is a low-cost standard service, and we have assessed the risk across all of our customers based on the maximum liability of £1 million that we might have to pay to all of those. If we start monkeying around with individual liability caps and putting it up, our risk profile goes up, and logically, so should the price. So are you going to pay more, Jamie?
When we started having these pre-contract negotiations, you told me that we were an important customer to you.
I was joking. I say that to everybody.
Feel very used. So what I would say at the moment is you refer to not getting unlimited protection. I'm not asking for unlimited protection. I recognize that unlimited liability is increasingly rare in the market. I'm just looking for a liability cap that better aligns with the potential heads of loss from a data breach. And it just feels like 1 million, it just doesn't do the job. So from our perspective, it's going to be very difficult for me to agree to this given the sensitivity of the data that we're sharing with you.
Now, what if I were to tell you we have literally never had a breach, ever? And we never will. All right, let's see where we might land. There's the original clause. It takes 4 clicks, I think. 5. It is the green button, right? There we go.
Right. So this looks a little bit better. So each party's total liability to the other in any 12-month period arising out of or in connection with a breach will not exceed the sum of, we sort of tentatively square bracketed, 5 million, subject to further discussion with our internal stakeholders about what's an appropriate amount. But this feels a little bit better from our perspective. Firstly, we've now got a mutual liability cap. We look a bit better for a breach in year 1, so we're protected on that front. And the figure of 5 million, if that's where we do end up, feels a little bit better aligned with some of the potential losses I might suffer. Whether 5 million is the appropriate number is clearly dependent on a number of factors, but I think we are seeing in the market separate caps for data protection breaches from the standard contract cap as an increasingly common position.
On these facts, I would say this, wouldn't I, right? This feels a bit high. If a lawyer agreed to that, it would be career enhancing externally, as they say. I mean, I think on these facts, maybe having a liquidated amount works. Normally, a formulation where it's linked to the fees is better, I think. Here, we just went with it because we had to fit it on the slide. That was the other thing. Right, there endeth our 4 points. I'm going to declare that I won. Now, we'll say honours shared. You won. Fine. You won, right? Customer won. And just a few conclusions, just very briefly.
Yeah, so the first thing to say is we've talked a little bit about what market standard is. I think we have to recognise that in certain areas there's still some evolution in what a standard position is. We're only a year out from the GDPR coming into force, and I think people are still grappling with the shift in dynamic in terms of the liability position and how that impacts where you end up on certain contractual terms.
And the second point there about GDPR obligations, the direct obligations on processors do seem to be making a difference in negotiations. So whereas, at least in the UK in the past, as acting for a processor, you might say, what, you want me to warrant the security is appropriate? That's an outrage. How can I possibly, all the arguments I just made, it's quite hard in the face of somebody saying, well, you've got to do that anyway. That's what GDPR requires. It's hard, I think, for a supplier to try and wriggle out of taking on obligations that it literally already has by statute.
The third point is one that Mark brought up during the negotiation, which is the fact now that the processor can be subject to a fine directly for a breach of security, and therefore the liability may well fall on the processor anyway, and you're not trying to offset the entire liability that would pre-GDPR would fall on the controller through the contract, means that you might be more amenable from the controller side to take a view on the likelihood of receiving a big fine yourself for a breach caused by a processor.
One other point, sort of looping back a little bit, the situation where, for a cloud deal or a standard service deal, the sort of thing we've just done is pretty straightforward. But if you think about a sort of old-fashioned, dare I say, outsourcing, where an IT company goes into a customer and essentially buys all of its kit, all its legacy equipment, everything, including the people, would 2P in, and from the next day provides the same service back, but as a data processor. In that situation, because it's a processor, it's got its own liability and responsibilities under GDPR. It is entirely dependent on the quality of the kit that it just bought. And that's probably the best example we've thought of where the processor is a little bit exposed, if you like, through being so dependent on what the customer has given them by way of their legacy equipment. Has it got good security? Maybe yes, maybe no. The other thing we're seeing is that even those suppliers out there who aren't themselves subject to GDPR, they just don't meet the jurisdictional test. If they are providing services into the EU or situations where GDPR does apply, we found them to be reluctant initially, saying, oh my God, we don't want to become subject to GDPR. And you explain, well, you don't become subject to GDPR just by doing business with somebody who is. But then explaining that if you're going to sell to companies in Europe, you've got to provide them a contract that enables them to meet their obligations under GDPR. You're not going to get anywhere. That seems to be landing, I would say, at least with most of them. And then the final point here is we've all got Article 28 to comply with, the controller, the processor, and it's pretty prescriptive. So the room to maneuver the difference between good and bad, assuming the contract complies with Article 28, is very narrow, I would say. The one big thing that isn't covered by Article 28 is liability. And so you could still have a very big difference between a good liability position and a bad liability position and something that complies with Article 28. But all the other issues, audit, subcontracting, all the rest of it, the range, the window of acceptable positions is narrow, I would say. Are we out of time? Stuart, how are we doing? Do we have to start busking and kill for time? Or?
Karaoke.
Well, I've been working on some new material, so. Should we keep going? Is that, yeah? All right, so the final slide. Just some other conclusions here.
Yes, I think just a recognition here, obviously, that was a bit of a snapshot of 4 areas that we thought were interesting. There are a range of other issues that can get very contentious, and I've just seen Bruno, can get very contentious. Audit, and the issue with audit, it does tend to vary depending on what type of agreement we're dealing with here. So for a pure cloud agreement, what you might get from a cloud provider in terms of the level of inspection you can make on their premises, you may be more reliant on third-party certification.
Yes, and I'll group these together. So controller's instructions, controller warranties. We are seeing a little bit more activity in this area, I would say. So pretty common for the processor to seek a warranty that says, from the customer saying that your instructions won't put us in breach. That seems okay. There's a bit of detail around it. We are also seeing controllers being pushed to give warranties saying things like, you'll only give us data where you've got the consent to do so and stuff like that, which obviously that's much, much harder to live with. And probably the compromise that we end up with typically is something here on this middle point about compliance with law. So each party complying with its respective obligations. So controller has controller obligations and should be able to warrant that they've complied with those. The processor can only really warrant that it complies with obligations that are directly on it as a processor. It can't tip over into saying, and everything we do will enable you as the controller to comply with your laws as well. So I'd say there's a little bit of back and forth here. Probably no different for GDPR, though, than compliance with law generally in other areas on a typical outsourcing deal. And final point, I think, is yours, Jamie, on assistance.
Yeah, so just to briefly mention breach response as well, quickly. Obviously, a part of this is getting a short time frame for a processor to notify you of a breach, but also alongside that, importantly, what level of assistance are you going to get as a customer, particularly from very large service providers who, when they're handling a breach, may be having to talk to a very large number of customers. So what level of assistance are you going to get in managing that process, managing any notifications you need to make, and things of that nature. And then linked to that, assistance generally, assistance with data subject requests, assistance with doing your DPIAs. There's a question about how this gets costed. So maybe a service provider will give you assistance with the rights request from a self-service perspective, but then if you want something additional, that might have to be priced differently. So that's another area where we see a bit of manoeuvring.